Hi guys, and welcome back to Contract B. This is video 2 for topic 9 of damages. So we'll get back in here. We've already had a look at nuts and bolts, causation, remoteness, mitigation, and we are now looking at the issue of calculating damages. Now, when you're calculating damages, here I want to emphasize. So when we looked in the early part of this unit at things like misrepresentation, tortious measure of damages. So what you're doing is you are awarding them tortious damages that arose as a result of the plaintiff relying on that contract, spending money to perform that contract, and so forth. So you'll get whatever it cost you to perform that contract up until the misrepresentation was discovered and you decided to rescind that contract. Okay, that's your measure of damages in torts. In contract, much nicer situation. If what you are doing is claiming damages in contract, you are to be awarded, in the usual case, so Robinson and Harmon says, expectation loss. That is, you've entered into a contract on the expectation that the other party will perform. And when they have not done so, things have gone wrong, there's been a breach, you need to be put into the position as if your expectation was fulfilled. That is, as if the contract had been completely performed. Okay, and this is where we get to claim for the profits that would have been made if the contract had been completely performed. So really remember that if you're ever in the situation of having to work out which kind of damages are best to claim for your client, if you're looking at something like lost profits, you're going to have to claim in damages in contract law. Damages are once and for all, so you can't just claim a bit here, a bit there, whatever. It will be a once and for all amount that compensates the plaintiff for the entirety of the breach that's occurred. That will only change if, for example, it's something like a continuing breach and you sue, you get recompense up until this date. If the breach is continuing, you'll have to sue later and get recompense for the rest. So, but generally speaking, damages are a once and for all thing. Damages also only cover net loss, okay? Your plaintiff can't be put into a better position than they would have been if the contract was completely performed, okay? Makes sense. Again, you are not trying to punish the defendant by awarding the net loss plus an amount of punitive damages. You are just getting that plaintiff back into the position as if the contract had been performed. Okay, Robinson and Harmon is the case that you need to be citing there. In terms of lost profits, well, this is where contractual damages are most at home. This is the natural living habitat of contract damages, according to Robinson and Harmon. Measure being the difference between the contract price and the value of the goods, the land, whatever it is, at the time of breach. Okay, so this is the example they give you in the text. A sells to B 10 tonnes of apples at $1,200 a tonne. B doesn't deliver, so A has to buy the apples on the open market. It has to pay $1,500 a tonne. So what's the measure of A's damages? The measure will be the loss of the $300 extra per tonne that they have to pay now that they're sourcing the apples from the open market. No real biggie there. That's just the home of contract law damages. Wasted expenditure. This is an interesting little beastie. It's not a separate head of damages. It is simply a component of the general award that is given under the Robinson and Harmon kind of scenario. So normally when you spend money in performing a contract, it's going to be recouped. If that's the case, then at the end of the day where there is a breach, the contract's terminated, you can claim for the expenditure you've made in performing that contract. Now, you will also probably be put into the position of claiming for loss of profits as well. And the example in the text is A contracts to build a house for B, all up price of $200,000. It's going to cost the builder $150,000 to build the house. They'll expect a profit of $50,000. If the builder partly finishes the job, spends $60,000, if the buyer repudiates, the contract's terminated, what are the builder's components of their damages award? Well, they're going to get that $60,000 that they've wasted in partially building that house, because that would have been recovered if the contract was completely performed. And they'll also get that $50,000 they would have made as profit on top as well. So your total award is going to be $110,000. Okay, you've got all of your expenditure recouped, plus you've also got your lost profits. Nice in terms of what you get under contract damages. Okay, so here we have Commonwealth and AMAN Aviation. Now, I've included this in our discussion of wasted expenditure because that's essentially the head of damage that the High Court awarded in this case, although the way that they discussed it was a little bit curly and circuitous, so we'll kind of unpack it briefly here. Generally speaking, in terms of wasted expenditure, you can only claim the wasted expenditure if, in fact, as we saw in our builder example, you were going to recover that cost as part of your net expectation from that contract. Okay, so because the builder in the example was going to recover that $60,000 that they did spend, as well as some profit, then when it came time to claim damages, they could claim their wasted expenditure plus their profit. Puts you into the position as though the contract had been performed per Robinson and Harmon. Now, here we have some complicated facts in AMAN. Don't need to go through them with you at length because you should already know them from your examinations in contract A. However, you know that they had a loss leader contract, so they knew, AMAN knew that they weren't necessarily going to make all of their costs back under this fairly short contract term that they initially got with the Commonwealth. So the planes had cost them quite a lot of money, more than $5 million. And if they were going to sell them and recoup the value of the planes at the time of breach, then it was only going to net them about $1 million. So they had, this $4 million hole. So this was definitely a case that was worth fighting for AMAN. Now, originally, the trial judge said, well, no, we can't give you Reliance damages because on this first contract, it was no sure thing that you're going to actually make all of your money back. There was no surety of you actually recouping your expenses the first time round. It was only really, if you ever got a renewal, that would have happened. So under the Robinson and Harmon calculation standard, I can only give you what you would have expected under that first contract. And that was no profits really to speak of and no recoupment of your wasted expenditure. Now, on appeal to the Court of Appeal and then up to the High Court, the question was, well, what exactly was the expectation loss per Robinson and Harmon under this first contract? And certainly the High Court affirmed the lower court, the appeals court's view, in that you can't just draw a very firm boundary around the first contract in situations like this, because generally speaking there will be a presumption that a party won't enter into a contract as a loss leader kind of contract unless there's a fairly strong possibility that they were over time able to recoup their costs. Okay, it just doesn't make commercial sense. Now, in that kind of a situation, the onus flips over to the defendant to show that the plaintiff would not have been able to recover all of their expenses and therefore should not be awarded wasted expenditure as a head of damage. Now, what the AMAN aviation team argued was that that first contract wasn't just a discrete contract on its own. It also included, as one of the expected advantages, a very strong possibility of renewal, under which, as I said before, they would have recouped their costs. And because the Commonwealth couldn't show that AMAN would not have been able to secure a renewal, therefore the Commonwealth could not discharge its onus of showing that AMAN would never have made back its wasted expenditure. And on that basis, the court was able to say, well, what was the value under that first contract? It was to be able to make some revenue, wouldn't have made it back all of its costs, but the main expectation was this prospect of renewal. What was the value lost there? The recovery of the expenditure. Okay, so AMAN was really a case of lost opportunity. It didn't get a chance to secure that renewal. And what was the quantum of its loss? It was the wasted expenditure that it had suffered during that first contractual term. However, it's not always quite so easy to work out what the quantum of loss is where you're looking at a circumstance of lost opportunity. Okay, AMAN was fairly easy. It was just the wasted expenditure. But here, where you're looking at losing out on the prospect of concluding a more favourable contract with a third party, it's full of all sorts of contingencies, and this is really where it becomes apparent that the calculation of damages is much more of an art than a science. And probably the best case to give you an example of how courts go about looking at this stuff is the Poseidon case. And in the Poseidon case, you had Adelaide Petroleum negotiating with two different parties to start with, both Poseidon and also a third party called Pagini. Now, it had travelled a fair way along the track with Pagini, and it actually had developed some draft contract terms that it was fairly strongly, as a strong prospect, going to enter into with Pagini. However, we have then Mr. Sellers, an executive of Poseidon, making some misleading or deceptive statements under the old Section 52 of the Trade Practices Act to induce Adelaide to go with Poseidon. And Adelaide did ultimately sign with Poseidon, but then Poseidon found out about Mr. Sellers' naughty representations and backed away from the deal and said, oh, well, we can't perform on those terms. Now, what did Adelaide do? Adelaide then accepted Poseidon's conduct as a repudiation, terminated the agreement with Poseidon, jumped back over the fence to Pagini and said, can we please conclude that arrangement that we almost had on foot before we jumped ship and went with Poseidon? No pun intended.
Poseidon adventure.
Pagini at this point sees a commercial opportunity to secure better terms for itself, and that's exactly what it does. So the contract that Adelaide ends up with this third party, Pagini, at the end of the day is less favourable than the original terms it would have got with Pagini under their draft contract. So Adelaide then sues Poseidon and naughty Mr. Sellers under that accessorial liability that you have under the Competition and Consumer Act for its loss. Now, what was its loss here? You see a lot of angst, particularly by Mr. Justice French. It's a very, very difficult case to work out here because you had in this party, in this contract with Pagini, you had 7 different conditions precedent that had to be satisfied before that contract would get up and running and be favourable to Adelaide Petroleum. So what Mr. Justice French does is he says, well, I'm going to take what you've lost, the more favourable terms under your original agreement, compare them to the terms that you ended up with, And that will be the base calculation of your damages. And then from that, we need to subtract the possibility, the percentage possibility that that ultimate contract with Pagini would never have actually clicked over into completion and benefit. And what was subtracted there was about a 60% chance that that ultimate contract would never have eventuated. So you see the High Court then wrestling with the whole idea of calculating lost chance, and not surprisingly here they were very reluctant to disturb the findings by Mr. Justice French, and they came down on the side of upholding that decision. So that's the issue of lost opportunity. In terms of rectification, again, it's just another way of looking at Robinson and Harmon. If you need to get some damages in order to put you back into the position as if the contract had been performed for things that you need to do to make good the defendant's defective performance, then those kinds of damages will be awarded. We saw that when we were looking at the issue of defective performance a couple of weeks ago. The Tabcorp case is really just a further enunciation of this whole principle. We had a naughty lessee that had done some, must have been fairly atrocious alterations to the foyer of a leased premises. The property was actually devalued as a result of these alterations, and the trial judge had assessed the damages on the basis of the property value before the alterations and the property value after the alterations. Was only, I think I'm going to say, around about $30,000 worth of difference. However, on appeal, right up to the High Court, it was held that, as you can see there, $1.38 million was awarded to the landlord. Why is that? Because per Robinson and Harmon, you need to be put back into the position as if the defendant had actually performed the contract. And here, if the defendant had performed the contract, they would never have done the alterations in the first place. So the plaintiff should not be forced to accept those alterations. They should rightly be able to put the foyer back into its original condition, and that was going to take about $1.38 million worth of construction work. So that's exactly what they got. No rocket science there. If there's something that needs rectifying, then it's just an additional head of damages you can get under Robinson and Harmon. And here we come to probably my favourite topic to discuss in the whole damages and calculation issue, and that is damages for mental distress. Courts are very, very shy of awarding damages for mental distress because, as you can imagine, if I have contracted with another party and I expect to receive something in return, naturally, if there is a breach by the other party and I don't get everything that I expected, there's going to be some disappointment. There's going to be some mental distress. And then once you open the doors for claiming that kind of damages, where do you draw the line, really? And so courts have been worried about this kind of tidal wave of claims. If they say, yes, okay, as a matter of fact, under Robinson and Harmon, you can claim damages for mental distress. What they've tended to do is say, no, really, we're all concerned about the economic losses that are suffered by a plaintiff rather than those fuzzy, kind of hard to quantify issues of mental distress. So there's really only a very few exceptions to this rule. And the first one is where you've actually suffered some kind of physical discomfort or inconvenience, and that is directly related to the breach, and we'll talk about that in just a second. The other one is where the contract is to provide pleasure, enjoyment, or freedom from mental distress. Now, if the very core of the contract is to provide you with freedom from mental distress, and then as a result of a breach you get mentally stressed, then damages should flow, okay? So that's the two fairly common sense exceptions there. Now, physical discomfort, I love these two cases. Hobbs and London and South Western Railway. And here, 19th century case. Mr. Hobbs and his wife buy a train ticket to get to a destination. I think it was Wembley to Hampton Court or some such thing in London. The train was stopped. There was some mains repairs that needed to be done. And so Mr. and Mrs. Hobbs decide, well, how are we going to get to our destination? We have no other real choice but to get off and go to our destination on foot. Now, the problem there was that it was a very rainy, cold evening, and certainly Mrs. Hobbs, I think also Mr. got sick, caught cold. And so what do you do in that kind of a situation? I know I would sue. Anyway, dear old Mr. Hobbs sues for breach of the contract that was concluded when he bought the ticket to arrive at that destination. Now, as I said, score, yay, £8 damages. Why is that? Because the physical discomfort that he had to endure walking from where he was dropped off by the train, where it was stopped, to his ultimate destination, that inconvenience was a direct consequence of the breach of the train company in failing to deliver him to his destination. So he could get the £8 for that inconvenience. However, the further loss that flowed on from that as a consequential loss, okay, an indirect loss, was him getting sick. So he couldn't get damages also for the consequential loss. He just got damages for the direct loss of the inconvenience of having to walk to his destination. Okay, rather delightful case there. The next one, where the whole point of the contract is freedom from distress, and you get distressed because of a breach, you'll probably get damages. And here we have Baltic Shipping Company and Mrs. Dillon. Poor Mrs. Dillon. I'm not sure of a contract law case that involves more bad luck, but dear old Mrs. Dillon bought a cruise ticket for the Mikhail Lermontov 14-day cruise. She was very much looking forward to it, and then on the 9th day the ship sank. Now, Mrs. Dillon lived. She was a survivor. And what do you do as a survivor? You sue in contract law. I love it. Now, there was a couple of different claims she made. The first one was in restitution for recovery of her fare, and we can talk about that a little bit more when we talk about restitution. But for present purposes, she also claimed damages for her mental distress. Not surprisingly, I think if I had gone down with a ship and battled for my own life, I probably would claim mental distress as well. So was she able to claim, was the question there. Yes, she absolutely was, because the nature of buying a ticket to have a cruise, a pleasure cruise, was freedom from distress. And obviously, when you're getting caught in the whole ship sinking scenario, that will cause you a fair amount of stress. So because that stress flowed directly on from the cruise liner's breach of contract, then she was able to claim her damages there. Again, one of the many memorable cases you will look at in contract law B. Maybe we could start a competition who thinks is the most memorable. We could vote on it. This would certainly get my vote up in the top 5 anyway. So that's damages for mental distress. So the last thing that we need to discuss today is the issue of liquidated damages. And up until now, we've been talking about the kinds of damages that you'll get as part of an award of common law damages. In terms of what the parties agree between each other, it can be easier to stipulate that a certain amount will be payable for breach of any particular term or terms, rather than the party that's innocent having to run off to court, ask them to quantify their loss, get an award of damages, and so forth. It's easier if the parties can just agree, okay, if you breach this particular clause, you're going to pay me this amount of money. Makes perfect commercial sense. It's okay to include terms like that, express terms, setting out an amount of damages for breach, if that term constitutes a genuine pre-estimate of the kind of loss that is likely to flow from the breach that's stipulated in that clause. Now, the problem is that often when parties include liquidated damages provisions, what one party is really trying to do is make the other party stick to the bargain, okay, perform the contract as has been agreed, virtually in terror of the fact that they'll have to pay these huge, exorbitant liquidated damages if they breach any particular term or terms. And the courts call that, an objective of getting the other party to perform in terrorem. That is, in fright of having to pay this awful amount of liquidated damages. Now, if that's what one of the parties is construed by the court as trying to do, then that clause is going to be void under the doctrine of penalties, okay? Void and unenforceable. And then obviously you're thrown back on your common law rights to damages. So you're going to have to go through that exercise of quantifying your loss for the court. So that's the issue of liquidated damages. The main case here is the old Dunlop pneumatic case. So we just had some fire alarms go off in the apartment block, and I had flashbacks of Mrs. Dillon. Good old Mrs. Dillon got me through. What we need to remember about this case is that it was decided in 1915. So that may explain some of the more difficult factual aspects of the case that we would see in the decision nowadays. But we had Dunlop agreeing to supply tyres to New Garage in return promising not to unduly deal with Dunlop's trademarks, and also it promised not to sell less than a certain listed price or to deal with customers at less than a certain listed price. Now, the trademark issue is one that the court spends a fair bit of time on, and it's something that would be still, a valid concern nowadays. And, something for which you could demand, if there was some kind of wrongful dealing with your trademark, you could demand liquidated damages for that kind of breach. However, agreeing not to sell than a certain listed price or to deal with customers less than a listed price would be a naughty no-no under the Competition and Consumer Act nowadays. You certainly couldn't extract those kinds of terms from another party to a contract. Now, the parties did agree £5 liquidated damages for each tyre that New Garage sold in breach of this agreement. You guessed it, New Garage sold for less than the listed price. Dunlop claimed its liquidated damages. The court had a look at the £5 mark in terms of, was it a penalty or was it a genuine pre-estimate of loss? In that case, they held, I think fairly surprisingly, it was a genuine pre-estimate of loss. It's surprising when you consider that £5 in those days per tyre would equate to approximately, in today's dollar value, more than $500 per tyre sold. So I kind of have an issue with looking at that as a genuine pre-estimate of loss rather than a penalty, but nevertheless, the way the court talks about Dunlop wanting to secure the integrity of its brand, I think really explains a lot of why this was found to be a genuine pre-estimate of loss rather than a penalty. But that's the factual scenario that went down in the Dunlop case. What came out of that decision is really the gold that we need to take away in today's terms. So Lord Dunedin wrote the decision that you need to get yourself familiar with, and he said a couple of points that you need to consider whenever you're looking at the issue of whether something is a genuine pre-estimate of loss or a term that's meant to hold the other party to performance in terrorem. The essence of a penalty is that issue of in terrorem. The essence of liquidated damages is that it's something reasonable, okay? It's a genuine pre-estimate. And calling a term liquidated damages won't convert a penalty into a genuine pre-estimate of loss. The court's not going to worry about form. It's going to look to the substance of what the parties agreed, essentially. And the factors that he set out were, it'll be a penalty if you look at the greatest loss that could flow from the kind of breach that has been stipulated, and you compare it with what the parties agreed, and you find that what the parties agreed was extravagant or unconscionable compared to the quantum of loss that would ordinarily flow from the breach. If it's some kind of disproportionate amount, then it's more likely to be held a penalty. Also, it's going to be a penalty if the triggering event for payment of this sum of money is the failure to pay money on time. Now, if the liquidated damages are going to be far and away above the amount that was actually defaulted on, then again, it's probably going to be a penalty. Similarly, and this might trigger off some bells in terms of innominate terms or intermediate terms, if you've stipulated a penalty, but it's triggered by a breach or some breaches, some of which might occasion only very trifling loss, and some breaches may involve very serious loss, and the payment of the liquidated damages, the amount is the same for either, then it's probably going to be a penalty. So they're the main takeaways from Lord Dunedin in the Dunlop case. And that is the issue of liquidated damages. So you can certainly try and specify an amount in your contract to get around the whole problem of having to go to court and quantify your loss and that kind of thing, but you have to do it very carefully. You have to do it with some reasonableness, otherwise you have the problem of that clause just being struck out, void and unenforceable, and then you've got to go to court to quantify your loss anyway. Okay, so that is the issue of damages. And like I always say, if you have any queries or questions, send me an email, post up something on Moodle, post message me, post something on Facey. I'm sure we can clear things up. Other than that, I look forward to seeing you in a Zoom session sometime soon. And thanks, guys. Bye for now.